Good morning, everybody. Thanks for joining us. We're just going to give it a minute here. We have a lot of attendees entering the webinar right now, so we're just going to give them a minute to get in, and then we'll get started. The numbers are continuing to climb a little bit, but we'll go ahead and get started so we can get you out of here on time. So thank you all for joining us for our 2023 Minnesota Legislative Webinar Series. Our first session today is about our non-compete agreements. So we have Julia Corbett here from Bleth & Behrens and Leah Davis from Abdo Workforce Solutions to talk about this very important subject. So I'm just going to take care of just a little bit of housekeeping items here before I hand you over to the two of them to get the information. So if you have any questions, you go ahead and put those in the Q&A part. We do have that option to upvote any questions. So if you see a question that you have the same question or you want to make sure that we get to, go ahead and upvote those and we will take care of as many questions as we can during the session. So if you have any technology or sound issues, make sure and put those in the chat and we'll help you out with those kind of things. And then after the webinar today, we will be sending out the slides, the recording, in a short survey that can just help us make our next sessions even better. If you recall, we have 3 more sessions after this one that are going to tackle some of those other legislative issues that came up this session. So be sure and join us for those as well. And with that, I will hand it over to our 2 speakers.
Thank you, Larissa. So again, thank you all for being here today. We've got there's definitely a flurry of impactful legislation that came through at the end of the last session up at the Capitol here in Minnesota. And so we at Abdo just feel very, very lucky to again be able to partner with the Bleth & Behrens Employment Law team and Julia Corbett to bring you this important information impacting all employers in the state of Minnesota. So again, my name's Leah Davis. I'm a partner here at Abdo. I oversee our Workforce Solutions team, which is a team of professionals focused entirely on HR and payroll related advisory and services. So I'll be sort of helping add some color to what does all of this legislation mean in real life, and specifically today as we talk about non-competes and any of those restrictive agreements that you might have with employees. And I'll turn it over to Julia to introduce herself.
Good morning, everybody. I'm Julia Corbett. I'm a partner, one of the managing partners at Bleth & Behrens. It's a law firm in Mankato. I lead our employment team here and have been practicing in employment law for almost 30 years. And so I'm here today to try to provide sort of the legal pieces and the dissection of the statute itself on the non-compete agreements, and also provide you some thoughts about how we think it's going to play out as we go forward. So I'll be talking to you about a number of issues. We did send out the statute in advance, so hopefully you got that, had a chance to take a look at that. We'll be working through that statute this morning, and then again talking about some of the ways we think it's going to play out.
All right, so today's session, we have 90 minutes and want to kind of tackle things in a little bit of a sort of strategic order. So we're going to talk a little bit about I'm going to tee it up and let the legal team give us a little background on the history of these non-competition agreements, right? So what has the state of Minnesota, how have they handled them in the past? What has the status quo been up to this point? And then we're going to focus on, and now what, right? What does the new legislation mean? What doesn't it mean? Who does it apply to? How is it going to impact day-to-day operations for a lot of your organizations? Then I'll be spending some time with all of that in mind, giving you some really important considerations that you need to be thinking about as employers. A lot of this ban, what you'll see is really a game changer for employers that have relied on non-competition agreements to protect, certain operational and business interests. And so we're going to have to get creative and think a little differently about how to do that. So we're going to talk through some of that. Throughout the session, as Larissa said, please feel free to submit your questions. If you don't have a question, but you want to watch those that are being submitted, again, you can upvote those, and that helps us sort of prioritize the questions that more participants have. And we will be covering we'll be taking time at the end of the session to tackle all those important questions. So I'll be monitoring that. All right. And then again, particularly when it comes to new legislation, it's important to just put out there, we're trying to get you the best information and the things to think about, but you are most definitely going to want to be working with your legal counsel to address your specific facts and circumstances related to how you're gonna tackle a lot of these things, going through your agreements, those types of things. So today's we're going to give you as much information as we can so you feel equipped to do that. Before we kick off too, and Julia, as we sort of tee this up for your section, I think it's important to have a conversation about when we talk about non-competes and some of these restrictive agreements, obviously the regulations coming out of the state apply to every single employer. We're talking one employee up to thousands of employees across every segment. There just really are no exceptions to these rules. But one thing, as we look at the different sectors, I think this is really, really applicable for our business owners and those business employers. The not-for-profit sector, there are definitely implications and situations where this could apply. But the public sector, so cities, counties, school districts, municipalities, there's definitely a more limited sort of set of circumstances, if any, that this would apply due to data practices, data access and sort of the lack of competition situations that would come up for those employers. But at least worth noting, it may not be as applicable in the public sector, correct? All right. Okay, so I'm going to turn it over to Julia to just kind of give us what has the lay of the land been up to this point.
All right, so one of the questions says we never received a copy of the statute. So it was supposed to go out ahead of time. That might have gotten overlooked. If it didn't get out ahead of time, we'll make sure it gets sent out. If you didn't get it yet, you will. And I apologize if it didn't get out ahead of time. That might have gotten overlooked in us. All of this has come, as Leah said, in a flurry and trying to get ready and get information out to people. So we'll get you the statute. If I can find, while Leah is talking, if I can find the link quickly, I will post that. I'll type the answer in the Q&A and post it, and also post it in the chat. So it might be coming yet while we're talking today, and if not, we'll get it out afterwards. The statutory site, though, if that helps you, it's going to be codified at Minnesota Statute 181.998. So you can Google that, Minnesota Statute 181.998, and you might also find it that way, okay? But we'll get it to you one of many ways here this morning. So in terms of the history of non-competition agreements, generally under Minnesota law, they have been disfavored. And so what that has meant is that courts have traditionally scrutinized them very closely. Non-competition agreements under Minnesota case law include all kinds of things. They include your typical non-competes, that you won't go to work for a competitor, you won't go to work in a certain geographic area, you won't go to work within a time period within that geographic area. Those are your traditional non-competes. And often when clients call me and say they want a non-compete, that's what they mean, versus the broader version of non-competition agreements. But it's important to note that non-competition agreements covers non-competes, it covers non-solicitation agreements, it covers non-disclosure agreements, it covers your NDAs, your confidentiality agreements. So as we've historically approached these agreements, the rules sort of apply to all of those. They have to have consideration. They have to have reasonableness in terms of their restrictions. And so those rules all still are going to apply to those historical agreements. The non-solicitation piece has generally been a lot of different options. You have your traditional sort of non-solicitation of customers, clients, patients, the people that bring in revenue to your business in general. Sometimes that could be donors, But we also have things like non-solicitation of vendors, non-solicitation of suppliers. Sometimes those are important to an organization. If they sort of have a market cornered on a supplier, they might do a non-solicitation of supplier agreement. You might in the nonprofit world have non-solicitation of donors or volunteers, et cetera. So non-solicitation agreements can cover a lot of things, and that'll be important as we talk about this new statute. The agreements historically could be upheld if they were supported by consideration, and that generally was two ways you could get consideration. One is to make the agreement a requirement of employment, a condition of employment at the start of employment. So as you're making your job offers, to say you're required to sign this agreement as a condition of employment. And if you won't sign it, you're not going to be employed. And historically, as long as you did that at the start of employment, that was sufficient consideration. If the person was already employed by you and you wanted to get a non-competition agreement out of them, you needed to provide some other kind of consideration, which besides just continued employment. It had to be that they were paid something or got some benefit they weren't entitled to. Maybe it was an increase in pay, stock options, deferred compensation, new benefits. There were all kinds of things that could be consideration while they're employed, but you needed one of those two, either start of employment or good consideration while they were employed. The non-competition agreements also had to be necessary to protect a legitimate business interest and not broader than necessary in scope or duration. So we've historically had conversations about how long, generally less than 2 years upheld, but it depends on the industry. Anything longer than that was probably questionable. They had to be reasonable in duration. If your customers or donors or clients, patients are generally within 100-mile radius of wherever you are, you couldn't get a nationwide restriction. That would have been unreasonable. So all of those things are still going to be important as we talk about the new statute, okay, in terms of what can still be upheld. So that's the history of the non-competition. Let's move to the new statute. And the biggest key for the new statute, the most significant change, is that effective for all contracts or agreements entered into on or after July 1st, 2023. So that's an important date. It's coming. It's about 3 weeks away. Any agreements entered into on or after that date with a covenant not to compete in it, the covenant not to compete is void and unenforceable with some exceptions. So we're going to delve into all that, but that's the 50,000-foot view of the change in the law, is the removal of the sort of traditional non-compete. Now, when you look at the statute, when you get it and or look at it online, hopefully there's no legislators on here, or actually maybe hopefully there are. The statute is really not very well written. It's redundant, it's vague, it uses differing terms, I think potentially to mean the same thing. And so because of that, because there's some vagueness and some redundancies and some drafting issues within it, I think unfortunately, as you have questions about your agreements going forward and how to draft them for your legal counsel, you're often going to hear, at least for the first few years, we just don't know for sure. And this is our best guess. And so that's what you're going to hear a lot today in terms of your questions. We're going to give you our best guesses. But the way legislation works and our government works and our separation of powers, the legislature enacts laws, the executive signs those laws into law, and then the judiciary interprets them. And so we've got the first two steps done, right? The legislature has passed this law, the governor has signed the law, and so now it's just a matter of how is it going to be interpreted? And we don't really know that until it plays out in the courts. A lot of the onus behind this seemed to be the media coverage, and the legislative comments tended to be that low-income employees were being harmed by these non-compete agreements. I don't, in terms of the audience that's on here, I don't know how you all are using them, but I can just say from my experience in drafting them, I can't recall ever drafting a non-compete for a low-income worker. They are almost always your executives, your high-level salespeople, your research and development, your intellectual property type employees. they are generally not your low income workers, but this legislation covers everybody now. And so the majority of the clients I work with don't want non-competes for their low income workers. They want them for those higher level employees. And they're now going to have some questions about how best to protect that. The statute is based on the California statute in general, but the California statute is much broader in terms of its protections for employees, much more restrictive about what kinds of contracts can be drafted than our statute. So in some instances, we're hearing, look at the California case law to see what's likely to happen. I think that it may be instructive as we go forward, but the differences in the legislation are likely going to be impactful enough that I think Minnesota courts are going to have to figure out their own way. So we're going to work through the statute this morning. We're going to try to dissect it for you, each section, give you guidance and answers about as much as we can. But unfortunately, we say that lawyers love that, it depends answers. And in this situation, it's not so much it depends, we just don't know for sure until this plays out a little bit in the court system, which is probably going to be a couple years. So let's move on to these legacy non-competes and how they are enforced. That was a question we got ahead of time, a question I'm getting a lot from my clients. What happens to our agreements we have in place? So if they were entered into before July 1st, so questions have been asked. I just had a client this week say, I've got an agreement out there that's going to be signed this week. The employee's not starting till October. As long as it's entered into prior to July 1 and you want to use that language within your agreements, this is being entered into on June 8th, 2023. As long as it is entered into, it should fit outside the statute and not be a prohibited and void non-compete, the non-compete portion, okay? So they are still enforceable, but all the things that have been in place regarding these agreements historically aren't going to change. They're still disfavored under Minnesota law. You're still subject to all the prior legal requirements. They have to have consideration. They have to be reasonable in geography and duration and what they're protecting. I think what we think from a litigation standpoint, so I've told clients forever, if you're going to have these agreements, you have to be prepared to enforce them. And that means you have to be prepared for litigation. If you have these agreements and you never enforce them, nobody's going to follow them. Word is going to get out and your employees are going to go and they're going to violate because they know you won't come after them. And so from a litigation standpoint, one of the keys that we've had historically is to try to get an injunction, and an injunction's early in the litigation to try to stop the employee from doing what they're doing. And often that meant getting some kind of order saying they got to stop working for this competitor right now while we sort this out. Injunctions have become harder and harder to get. And I think with this statute, and part of the reason they're hard to get is that because the agreements are disfavored and because the courts have historically said public policy is against these agreements. Public policy is for people being able to be mobile and to use their skills where they best see fit and not to be bound by this contract. And so now we have a statute that enforces that public policy, right? Reinforces that public policy and says, yep, not only is public policy against it, we've banned them. And so getting an injunction early on is likely to be difficult, more difficult than it was. It already was difficult. It's likely to be more difficult than it was. If, however, an employee leaves and violates your non-compete, and you can actually prove damages, I think courts are still going to enforce that, most likely. That's my best guess, that if you can actually show damages on the non-compete, that they leave and they take some important research and development portion of your business away. They take some sort of secret and you can tell they're using it. You've got damage as a result of that they leave and they compete and you have clients leave or customers leave or vendors reduce the work they'll do with you and you have actual damage because of it. I think you'll still be able to get courts on those legacy agreements to enforce the damages. I think the injunctions are going to be harder, but they are still enforceable. The question is just how much are courts? Courts aren't going to be able to look at them and say, no, this is void under the statute. That they're not going to be able to do because they're entered into prior to July 1. So hopefully that answers the question sort of on those legacy agreements. If you have more, put them in the Q&A and we will try to get to them. All right, we'll move to the next slide. So let's talk about some of the key definitions in the new statute. So first of all, this new statute applies to employers, and an employer is kind of anybody. It doesn't matter how many employees. It's an individual, partnership, association, corporation, business trust, or any person or group of persons acting directly or indirectly in the interest of an employer in relation to an employee. Now we have to define employee. So that's the next definition. And so the employee is any individual who performs services for an employer, including independent contractor. A couple of things about this. We believe that employee is going to be interpreted to include owners, members, partners, shareholders, that they're not going to be excluded from the employee. When we get to the exceptions, you'll see why, because there's a carve out for business sales involving those people that you can have non-competes for them. There wouldn't be a need for a carve out if they weren't covered under this broad definition. We wouldn't have to carve out an exception for them. And so given that any individual who performs services for an employer would, and an employer is any business. And so ultimately you've got owners performing services for a business. If they're an active owner, they're likely to be an employee. Your passive owners might not be, if they're really doing no services for the employer. You'd have to be careful though, because I think even potentially board service could be a service for an employer because it's a business, right? Doesn't say it has to be employment services, although the employer definition is talking about acting in the interest of an employer. So the board service piece, I think, is maybe a reach. Passive owners should be relatively safe. Active owners and active employees are likely to be employees. All right. So then, independent contractors I wanted to cover here. So that's new, right? Employees, independent contractors are not employees, but under this statute, they fit that definition. And so independent contractors here's an example of poor drafting, because this says an independent contractor is an individual who performs services for an employer. Well, the independent contractor and the employer, they're not a relationship, an employee relationship. So we've got independent contractors within employees. In my experience, independent contractors generally have not been people who need protections from these agreements. They often are coming into your business for a short period of time. They are a risk from a competition standpoint. You're going to give them information about your business for them to help you on a short-term basis or a project basis. And you don't want them to take that information and use it against you, or to go out to your competitors. You know, if you're hiring a marketing agency as an independent contractor and you don't want them to compete with you in your industry, and now they're going to be an independent contractor within this definition, and there's the non-compete provisions are going to apply. And so historically, independent contractors seem to be, from my perspective, sort of a safe place to do those non-competes, because they can negotiate their own contracts. They tend to be business people who understand the pros and cons and what they're getting into. And, but they've been protected now. So that might, I think we could see some impact on how much businesses are willing to engage independent contractors and how they're willing to engage them when they can't get non-competition agreements out of them. The independent contractor definition is there. It's any individual whose employment, again, here's another word, they're not employed. It's really whose services are governed by a contract, and whose compensation is not reported on a W-2. And so it goes through, and it's an expansive definition of independent contract. So the definitions are important because they then factor into the rest of the statute. Every time they use the word employee or independent contractor or employer, you've got to refer back to the definition. Does this person or entity fit within the definitions? All right, we'll move on to the last couple of key definitions. So as I said before, the biggest piece of the statute is that covenants not to compete are void. So a covenant not to compete is an agreement between an employee and employer. So again, that now includes independent contractors and businesses, that restricts the employee or independent contractor after termination of the employment from performing work for another employer for a specified time, work in a specified geographical area, or work in a capacity similar to their work for the employer that's party to the agreement. So this is your traditional non-compete. You can't go to work for a competitor within 50 miles of Belle Plaine, Minnesota. You can't go to work for another competitor for a period of 1 year. You can't, those more traditional non-competes are going to be void and unenforceable. The questions are going to be sort of in the, how much can you push the limits and how creative can you get in the drafting to try to get around this? But that's the basic definition and rule, right? This is what is void. What is not void is the next bullet, which is your non-solicitation and non-disclosure agreements. If you can, there we go. So a covenant not to compete does not include a non-disclosure agreement, your NDAs, your trade secret, your confidential information. You can still have those agreements. You also still can have your non-solicitation agreements. So again, going back, that could be customers, donors, volunteers, vendors, suppliers. It could be a whole employees, could be a whole host of non-solicitation options still available to you. And it doesn't include agreements restricting the ability to use client or contact lists or solicit customers. So again, like that's a non-solicitation agreement. So it's redundant and not sure why that's on the end, but I guess it gives us clarity that agreements that prohibit solicitation of customers are clearly okay. So these two last bullets, the non-disclosure and the non-solicitation, are the things that are still allowed and give us sort of that gray area to work in, okay? So let's move on to the next. Oh, actually, before I go to this, you can leave the slide here, Larissa. What I was going to say is on the non-solicitation agreements and the confidentiality agreements, I mean, to some extent, in some industries, they're not real helpful. You know, what we've said all along is non-competes are easier because if it's very clear you can't work within a specific area or a time frame, you know, that's sort of concrete. Solicitation can be a hard thing to prove. So let's kind of walk that through. Let's say Leah works for me and I have her subject to a non-solicitation agreement. And it says she can't solicit any of the customers that she's worked on while she's worked here at Blythe & Behrens. You can't actually have them in law firms. So we're going to assume I work for Abdo. And so Leah goes somewhere and her clients all just like her and go with her, right? And maybe she sees one of them out, you know, at dinner and says, oh, I'm over here now, would love to have you join me, right? Which would be a solicitation. But now if I want to try to sue Leah on a violation of the non-solicitation, my key witness is going to be that client who left me and went with Leah because they like Leah. And how likely are they to testify, yes, Leah solicited me? No, they're not going to. They're going to say, I went with Leah because I liked Leah. She did a good job when I worked for her. I figured out where she was. Yep, I ran into her, but she didn't encourage me to leave at all. You know, I asked her where she was and she told me. That's the kind of testimony you get out of those customers who have left. And so proving non-solicitation can be difficult unless you have that smoking gun. Sometimes I've had situations where employees have left and sent like, here's my new place, would love to have you come and be my client over here. I mean, if they're not smart enough to avoid that, you've got your smoking gun and that's easier to prove. But without those smoking guns, non-solicitation agreements can be hard to prove. It can also be hard to prove confidentiality agreements and violations of those. You know, if you've got somebody in research and development and they go somewhere else and, you know, 4 years later, this company develops a product, are you going to be able to prove they used your information, or maybe they already had it in development, or whatever the case might be? So both of those can be hard to prove, but they do still exist for you in terms of ability to use them. So we'll talk about the exceptions. So this is the exceptions to the covenants not to compete being void. So there are a couple of situations where you still can have covenants not to compete. So you can have the non-solicitation, you can have the non-disclosure. They still have to have consideration. They have to be reasonable in scope and duration and geography, all of those things. Those things all still apply to non-solicitation confidentiality. Non-competes are banned, except that you can get them if they are agreed upon during the sale of the business, and there's more language there, And then the covenant not to compete or the covenant not to compete is agreed upon in anticipation of the dissolution of a business. And again, it goes through that. Now, this applies to owners, not to employees. It only applies to the person selling the business or the people dissolving the business, and the people dissolving the business have to be the owners. Here's a place that I think there's a lot of gray area. I have a number of clients who have shareholders, members who as a part of the buy-in process, as part of their stock purchase agreement, their member control agreement, have non-competition provisions in them. We don't know how that's going to play out when that is entered into at the start of employment. What I think is that if you're careful about the drafting, and unfortunately this says, for example, the first bullet, it says it's agreed upon during the sale of the business. It doesn't say agreed upon during the sale of a business interest, which would have made it clearer, I think, because the sale of the business sounds like you're selling the whole business. And that isn't the case when you have generally ongoing owners, right? For the most part, that's somebody buying in and the other owners and buyers are agreeing. So I'm hopeful that this means the sale of a business interest, not the entire business, but we don't know for sure what a court's going to do with that. But I think if you're entering into those agreements, one option is to make sure your language is talking about that the current owners are selling their shares in the business or their membership interest in the business, and the other person is buying as a part of that sale these interests. If you can use the language of the statute, you might have some argument they're enforceable. I think that there's some other things that might be able to be done around these agreements. Things like, well, we'll talk about it in the key questions. I want to move on. We'll talk about some other things you can do on these, because I think these non-competes are ones that we have some real questions about, because they are the exception. So how do you take advantage of the exception, right? We'll cover that a little bit more in a minute. The agreed upon in anticipation of the dissolution of the business, every commentator and every other attorney I've talked to who practices in this area says, if the business dissolves, who's going to care if anybody competes in 99% of situations? If everybody's going their own way, but there might be situations where you're going to dissolve the business and you're going to agree, maybe one of the partners is going to get something more to continue on doing something similar, and they want everybody else to agree they'll stay out of their way. So there could be situations where you're actually dissolving the business completely, and this might play in. So these are two exceptions where you can get the non-compete agreements. All right, let's move on to some of these key questions. If we can advance the slide, Larissa, there we go. Okay, so some key questions and thoughts for discussion, or my discussion at least, and you're listening on the definitions. So what are the difficulties and concerns with non-solicitation agreements? As I said before, you almost need that smoking gun. And we've talked about kind of how that happens in litigation and how difficult they can be to prove. And the same thing is true with confidentiality agreements. They can be difficult to prove that somebody's using your confidential information. So while it's helpful we can keep those agreements, we're going to have to be really careful about their drafting and try to draft them in ways to best protect the organization. The strengths of the provisions regarding the non-solicitation and non-disclosure. And one of the things is that for so long, courts have said these agreements are disfavored. And so in general, non-competition agreements are disfavored, all of them. Well, now we have a clear ban on non-competes, but we also have a clear blessing on non-solicitation and non-disclosure agreements. So that's going to eliminate the ability of the court to say these are disfavored under public policy and law. They're not disfavored anymore. They're absolutely allowed under the statute. So the argument is that those agreements are more likely to be enforceable going forward because they've been blessed in this statute, that they're specifically in there as options. So what about third-party contracts? I've had a number of questions about this. So I think I had one from one of our school district clients. We have an agreement with an outside entity that does maintenance that we won't hire their maintenance workers, right? So we have an outside entity that maybe it's providing janitorial service, or maybe it's actual physical plant maintenance. And we have an agreement, we won't poach their employees. I mean, courts have to be strict constructionists. We have to go to the actual language of the statute. And the statute says that it has to be between the employer and the employee. So if you don't fit the employer and the employee, and so now we have two basically businesses, right? It's not, the employee is an individual who performs the services for the employer. That's not who the contract is with. Now, California courts say that those anti-poaching contracts are also non-competes, but their statute says it applies to any contract. Ours specifically talks about an agreement between an employer and an employee, not any contract. So I think there is a difference, and I think those third-party contracts could still be enforceable. Again, these are our best guesses. The next question is, what about provisions that say an employee can't do work for a former customer client? So a lot of times in non-solicitations, to help beef them up, we'll say that. We'll say you can't solicit them or do work for them, because now you don't have to prove they solicited, right? You can just prove, hey, they left and they went with you because they liked you, Leah. So that's a violation. I think there's a big question about that. I think it's clearly against the spirit of the statute, but again, courts have to be strict constructionists. So they have to look at the language of the statute. And if you look at the language of the statute, it doesn't fit that definition of non-compete, right? It's not an agreement that says you can't work for an employer for a specified period of time. It's not an agreement that says you can't work in a geographical area. And it doesn't say you can't work for an employer in a capacity similar to your prior work. It's just saying you can't do it for these clients. You can go work for them. You know, if you're Leah and you're an accountant, you can go work for them as an accountant. You can't work for our clients. Again, we'll talk about the risks of violation. I think that's one of those areas that an employer and an organization is really going to have to decide how much do they want to push the envelope and how much risk do they want to accept. I think there are definite arguments there that the statute doesn't prohibit that on its face. The spirit of the statute might be different and the court might view that differently. So you're going to have to be careful about those and be very choosy if you decide to have those kinds of provisions in your non-solicit. We also often see liquidated damages provisions in non-solicitation agreements. So sometimes in professional services organizations, it will say, if you leave and any of your clients go with you, you're going to pay us 150% of the fees that client paid for 1 year. Are those going to be enforceable? I would put those right back in with the prior question. I don't think they're strictly banned by this statute. They don't fit the three things that say what are banned in a non-compete, but they also don't really fit the spirit of the statute. And so I think there will be a question about whether those are non-competes or are they strict non-solicitation with a damage provision. And so it's a non-solicitation agreement. You can go work for whoever you want, but you got to pay us something if people go with you. So those two, the fourth and fifth bullet on here, I think are, again, questions about sort of risk management and how much risk an organization wants to take on. It's also been raised whether separations could be used to get non-compete agreements. Often, well, not often, it's not uncommon for an organization to slip a non-compete into a separation agreement when they're getting employees to waive claims and they're paying them for that, to also slip in a non-compete, either because they didn't get one in the first place and now they're worried about it, or they know that their first one wasn't very well drafted and they want to sort of shore it up. There's been a question about whether, can you do that, or is that a non-compete? Again, if we go to strict construction of the statute, it's talking about an agreement between an employee and an employer. An employee is somebody who performs services. So there's been some commentators saying, look, if you wait till you terminate them and they're no longer an employee, you terminate them on June 8th. And on June 10th, you go to them and say, look, I'm willing to pay you $50,000 for a 1-year non-compete and a waiver of claims. You'd throw it all in. Is that going to be valid? You'd have to have the timing right. It would have to be after they're an employee. I think there's an argument that could be outside the statute and thus valid. But there's also an argument, again, it's against the spirit of the statute, and how that's going to play out, we just don't know till we see some of these cases play out. And whether you as an organization are going to want to be the guinea pig or not is going to, is going to be a question. So these last three are riskier options, but they may be options available to work around the definitions in the statute. So let's talk about some key questions and thoughts in terms of the exceptions and the effective date. How will stock purchase and member control agreements fit into the sale of business exception? I talked about that a little bit already. I think there are questions about that. Clearly at the end of the relationship when you're selling, you can get it. But most of the time, these stock purchase options, member control agreements set a way that you're going to determine your price, and you're getting the non-compete as part of that. And so if you have to wait till the end and somebody's leaving, you're probably going to have to throw some more money at them to get this non-compete as part of the sale of the business, most likely. If you have one owner leaving a group, for example. I think there may be ways to get it in at the start if you're really careful about your drafting. Some other things that we've sort of talked about is potentially forfeiture provisions. So if you're going to get X upon departing, you're going to get that, but now it's going to be subject to that you won't go to work for whatever. And if you do, it's going to be forfeiture. That's a little bit similar to those liquidated damages provisions in non-solicitation agreements. Is it against the spirit of this versus is it strict construction happening? And those are the things we don't know a court will do. But I think there can be some options around that. And often, those are probably the non-competes that, at least for many of my clients, are sort of their most important. Those significant owners are making, significant salaries. They've got stock options or membership interests that have significant value, and it's important they not compete when they leave. So we're going to have to do some thinking about that, and organizations are going to have to decide how much risk they want. It also may affect business valuations and retention of key employees in those business sales. From a mergers and acquisitions standpoint, oftentimes a buyer is willing to pay a certain amount for a business because they understand they can retain key employees. And I don't want to get too far into the weeds on mergers and acquisitions, but if you do a stock sale versus an asset purchase agreement, in an asset purchase agreement, most of the time, well, almost essentially all of the time, the employees are being terminated and rehired. And you're going to provide them with new non-competes. Well, if it's after July 1, 2023, you're not going to be able to provide them with the new non-compete. You can do the non-solicitation, non-disclosure, but you aren't necessarily going to be able to tie them down on the non-compete. So that might impact what you're willing to pay for the business or what the seller is going to be able to ask in terms of asking price for the business if we can't guarantee those key employees staying. In a stock purchase sale, generally the employees continue. So if there are non-competes, arguably, and they're legacy non-competes from before July 1, arguably they'd continue forward. But if they're not well drafted, you're not going to be able to get new ones out of those employees. You're going to be stuck with the agreements you have. So I think we could see some impact in mergers and acquisitions in terms of whether people want to do stock sales or asset purchase sales. There's other pros and cons from a tax standpoint. And other issues to be considered, liabilities standpoint, all kinds of things to make that decision. But I think this is now going to be one of the discussion points, is whether we can retain key employees and how does that affect value. We already talked about if the business is dissolving, does anybody care? They might. I don't see that one being used as much. And then can you reaffirm legacy agreements? And we actually had a question about, can non-competes be re-signed annually? I would say no. If they are signed again after July 1, that is going to be a new agreement. Once you have a non-compete, there really is no reason to keep re-signing. I think you create more issues for yourself to some extent to keep re-signing an agreement. Which agreement is in effect and when were they signed and did you give consideration and all of those things. So generally you get the agreement in place, and unless you're making some significant change to it, you don't re-sign. I think it's pretty clear that if you try to reaffirm these agreements after July 1, so when sometimes, like I said, in a non-compete situation and a termination situation, historically, if we saw a bad one, we'd put it in the agreement and just say, we're reaffirming that agreement and you now have additional consideration and you're agreeing it's reasonable, it doesn't unreasonably restrict you and all those things, and you're reaffirming that agreement with us. I would be very careful about doing that. If you have agreements, let them sit. Don't try to re-up them. Don't try to bolster them. Don't try to make them better unless you can do it before July 1st. If you know you have bad agreements and they're important to you, you might want to look at them quickly and try to bolster them. And you're going to need to do some consideration to get different agreements between now and July 1. So legacy agreements and reaffirmation, I think, is going to be dangerous. Again, that's our best guess, but most of the people in the industry that I'm talking to around this, most other lawyers who do this work are thinking the same thing, that reaffirmation and trying to re-up those legacy agreements or reinforce them later is not going to work. Most likely they're going to be agreements entered into. That's the key word, right? They're entered into after July 1. They're not entered into back in 1979. It's now entered into in 2023. And if it's after July 1, then the non-compete's going to be void. Okay, we will move on. One other thing, actually, before I talk about this, you can leave the slide, Larissa, we're fine. There are these things that we call either term of years agreements or what we call garden agreements. And garden agreements means essentially that you say, I say to Leah, I don't want you to do any work anymore, but I want you to sit on the shelf for 2 years and I'm going to pay you your salary. I just don't want you to work. You can't work. Can't work for anybody else. You can't independent contract. You can't do anything. You just got a garden for 2 years. Go sit in your garden, do nothing. There's a question about whether those are non-compete agreements or not. If they're still employed, then again, if you go back to the strict language of the statute that says it restricts the employee after termination of employment, they're still employed by you. So you can restrict people still while they're employed. You can say you can't compete with us while you work for us. That's not banned by the statute. It's what happens after they leave. So in theory, these sort of term of years or garden agreements where you're saying you won't compete with, essentially, you aren't saying you won't compete with us in so many words. You're saying, you can't work for anybody else. You're our employee, can't compete while you work for us, and we're going to pay you for 2 years. We don't want you to work. That allows you potentially to shore up your customers, your clients, all of those things. I can see that happening. I mean, it currently only happens in very limited circumstances because it's often a significant outlay of cash for a business for somebody doing no work. But in a situation where it's important enough, it might be a situation where it's something you want to look at. All right, the statute also has some choice of venue restrictions. So basically what this says is that if the employee resides and works, it's not an or. So again, that's how they drafted it. They have to reside here and work here. So if you live in Hudson, Wisconsin and work in Minnesota, this doesn't necessarily apply to that employee, right? It's an employee who resides and works in Minnesota. If they reside and work here, you can't force them to submit to jurisdiction somewhere other than Minnesota. So let's say you're a company with an operation in Minnesota, but your headquarters is in New York. And all of your non-competes say, if we get into a dispute, it's going to be decided in New York by a federal district judge in New York or in this district in New York. If your employees reside and work in Minnesota, they're going to be able to choose that. You can still put it in the agreement. And if they don't fight it, you can have it held in New York. But if they fight it, it's going to be in Minnesota. So it says you must not require an employee to agree to a provision that would do either of the following. And if it violates this, it's voidable by the employee. So I would suggest you don't even want those jurisdictional provisions in there because of the risk of some of the other violation issues that we're going to talk about in a second, the risks if you violate the statute. But arguably, what this would say is if it does contain it, then it's voidable by the employee. And they can say, I don't want to go to New York. I want to be in Minnesota. And that's what's going to happen. Now, if an employer in Maryland has an employee working remotely in Minnesota and they reside here, that Maryland contract can't say it gets decided in Maryland. Even if that employee is just sort of on an island by themselves in Minnesota, it's their only employee here. Their contract has to say, it shouldn't say it should be decided in Maryland, even if it says that it's going to get decided in Minnesota. And adjudication includes litigation and arbitration. So that means your arbitration provisions also can't force them outside of Minnesota if they live and reside here. So that one's a little bit more narrow. It's a little bit more clearly drafted. Unless you're a really big organization with headquarters elsewhere I don't see it being as applicable to a large majority of employers. Most Minnesota organizations that are headquartered here, based here, have most of their employees here, have Minnesota already as their jurisdiction. And so they're not going to be impacted by that. If you have Minnesota as your jurisdiction, you're going to be fine as to your Minnesota employees. Now, there are states all over. I mean, California is very broad. Probably can't, I don't think you can, in fact, submit a California employee to Minnesota jurisdiction. So if you have employees in other jurisdictions, hopefully you already know you need to understand that you need to comply with the laws of those jurisdictions. This is our law, the Minnesota law we're talking about today. All right, we'll move on. That's the choice of venue restrictions. And then this is essentially kind of our last slide before I turn it over to Leah. So the remedies for violations. So in addition to injunctive relief and any other remedies available, a court may award an employee. So nothing about the business, right? And what the court can do for them. What the court can do for the employee who is enforcing their rights, they can award reasonable attorney's fees. So the bottom line is the financial stakes could be pretty high. If you want to push the envelope on these agreements and you're determined to have violated the statute, not only can the employee get an injunction saying, well, they've got to stop doing what they're doing to me, but they also need to pay my attorney's fees related to the litigation that's happened, related to the correspondence between attorneys, related to whatever has happened. And those attorney's fees, you know, can be high if you have litigation around a non-competition agreement. They can be significant. And so you're going to pay your own attorney as an organization, and you may also have to pay the employee's attorney. Here's what I think most of us who work in this area are hopeful will happen. Because it's permissive, because it's a may, that means the court has a choice to award the attorney's fees or not. Because the language of the statute does have some vagueness, and there are some questions about, you know, does a non-solicitation agreement include you won't work for our clients, or if you do, you'll pay us liquidated damages. Is that within the statute or is that a violation? We don't know yet, right? And there's a good faith argument that it's not a violation based on the strict language of the statute. Our hope is that as the case law develops over the next probably, you know, 2 to 5 to 10 years, that and especially in those early years, 2 to 5 years maybe, that courts won't award attorney's fees if the employer has a good faith argument about it. Now, if you just do a straight up non-compete, you're probably going to get attorney's fees awarded against you. But if you're fitting sort of in the gray areas, there will be an argument the court shouldn't award attorney's fees because it's permissive and you were reasonable and in good faith trying to follow the statute. We can't guarantee, though, that the court won't award attorney's fees. So that goes back to my statement. You're going to have to decide as an organization, how much risk do you want to bear in this? Do you want to be the guinea pig figuring out how the law is going to shake out? Or do you want to sort of take a safe stance initially, watch how it shakes out, and then adjust as you go forward? You know, sort of in closing on my comments, what we do know, your legacy agreements are still good. Those entered into before July 1st. You may not be able to get injunctions. If you can prove damages, I think you're more likely to get those, but they're still subject to all the same issues they were subject to before. The same kinds of comments of, we don't know if they're going to be enforceable. We don't know if a court's going to like it. A court may blue pencil them, which means change them on you. There's all of those things are still in play on those legacy agreements. We also know you can't do strict non-competes, your traditional non-competes for employees after July 1, unless it's part of a business sale or a dissolution of the business. We also know you can do non-solicits and confidentiality agreements. And if you're pretty traditional, you won't solicit our clients, you won't use our confidential information, those are going to be upheld as long as they're reasonable. Non-solicits, you know, they can't go forever, but a reasonable period of time, a reasonable geography. Confidential information you can generally protect forever. The confidential information usually survives employment indefinitely. So we know those things, but those gray areas are going to be the challenge, and where you're going to hear the answers from your legal counsel of, we just don't know exactly what a court's going to do with these things. We're going to give you our best guess, but we just don't know for sure. All right, I'm going to turn it over to Leah. We'll look at the questions and get some of the questions on this section and then the Q&A. Thanks.
All right, thank you, Julia. So before we get into this, now what? I think if you're like most employers, just take a deep breath, right? So hopefully by, after everything Julia's talked about, I think it should be clear to all of us that the game has officially changed as it relates to non-competition agreements in a variety of forms. And so one of the things as we're talking with employers, I mean, a lot of the work that our team does is, well, okay, now what? Now what in real life, boots on the ground, what does this mean for our organization? And how do we need to communicate that? How do we need to make changes to our policy, to our practice? How does this impact culture? How does this impact strategy? And so that's a lot of what I want to talk about right now. So if we start really, really high level, I think the biggest sort of question that employers should be asking themselves is, if I was using non-competes in the past, and if I'm really concerned about the inability to use them going forward, what exactly is it that I need to protect, right? What specifically with your organization is at risk? What's the timing of that risk? When is that risk greatest? So if it's I'm really worried that they're going to steal all my customers, right? We're worried about loss of revenue if someone leaves and takes customers with them. It's being very specific. We've in the past been able to sort of draft these very broad blanket non-competition agreements that even if they were, Julia talked a little bit about, even if they were disfavored by the court systems, at least they were there, right? There was a sort of a threat of action that at a minimum discouraged employees from doing what we didn't want them to do, right? But without that, we need to really understand the timing and the scope of our risk and start thinking about how can we sort of come at protecting that differently. The other thing too is, who are the most critical employees to restrict? I've had a lot of employers say, oh, well, I guess we had these agreements for, managers to, let's thinking of in a, CPA firm environment, managers to partners or whatever the sort of group of employees that historically had these agreements. Maybe we're not as concerned about one group. And so we need to align our strategy or develop our strategy about how are we going to deal with this going forward, more focused on a more sort of specialized or narrow group of employees. So be really honest, take a big step back. If they're gone altogether, where do you need to focus your time and energy on protecting the organization? Then once you've done that, we're going to have to get creative. They just took a tool out of the toolbox, and we have to figure out what we're going to do next, right? And so Julia talked a lot about taking a look at those non-solicitation, those non-disclosure, those owner agreements. It might be shoring up some of the language to try to get you a little bit of leverage and add some additional protection and to those agreements that, as Julia said, are sort of blessed by the legislation, right? As long as they're doing what they've historically done and they're not stepping into some of these non-compete terms, they've specifically said these are allowed. So it's maximizing what we can get out of those. Differently, but I think really importantly, employers need to think about if what we're really concerned about protecting, the area that is the biggest risk for us has to do with information, has to do with processes, trade secrets, those types of things. I think it's a worthwhile exercise to really ask ourselves, if we're so concerned that employee A is going to leave and have this really negative impact on our organization by taking all of this information with them, we should be asking ourselves, how much of that information do they actually need to do their job, right? So, these agreements have allowed us to sort of be very transparent with operations and client information and all of those things for some of these key employees. Maybe they don't need all of that in order to do their job well. And we need to be thinking about where we can trim some of that up in some cases, so that if they do leave without a non-compete agreement, they don't they can't sort of replicate your business on the way out the door, right? Or replicate whatever it is you're trying to protect. Julia also talked a lot about, I mean, these are options, right? These garden leave opportunities where if you have someone that there is no question that if they go to work for a competitor, your clients will follow them. And it's worth it to you to pay to keep them on your payroll long enough for your clients to sort of forget about them for a year. That's something that you potentially can do, right? And it's a big investment. But again, if we're really focusing on where is the biggest risk and doing sort of that cost benefit analysis, that may be something that you're able to do. As well as some of the benefit forfeiture, right? So if you have an owner or a key employee who is has a, you know, an unqualified deferred comp, a non-qualified deferred comp plan that has some language in it that says if you leave and compete, you're not eligible for X, or vesting is dependent on 2 years of non-competition around these terms. That may be language where it's a little bit more of a carrot than a stick. You get this if you sort of stay out of our way for 2 years after employment. That could be potential. But as with a lot of this, be careful, right? We think we understand or have an idea of how the courts will interpret some of this, but it is important to at least have in the back of your mind that none of this is a sure thing necessarily until we see some of it play out. And then the big question, the reality is, whether it's because of this non-compete ban or it's because of the changing dynamic in the workplace, what employees expect, what employees want from a tenure perspective, business as usual is sort of out the window, right? If we look back 5 years ago, there's 12 different ways that all of your workplaces have changed. And this is just another one of them, right? So here's the reality. Even with non-competes in place, I think any employer that I talk to is quick to say, yeah, absolutely. Our employees don't actually intend or even want to stay for their entire career with one organization. The statistics show that, right? So tenure expectations by demographic, as the baby boomers are leaving, like that average tenure for your 50 plus is pushing 10 or more years with a single employer. You get into your 30, 40-year-olds who, for a lot of organizations, those are your key employees right now. They're in that management role at that sort of stage in their life. Those employees are 4 to 7 years expected tenure. And in a lot of cases, they don't want to stay with one employer any longer than that. So those non-competes, I think, have been getting less and less effective anyway, right? So employers, we just have to sort of own that and figure out what does that mean going forward. One of the things that I'm having a lot of conversations with clients on is we've spent a lot of time and energy historically focusing on keeping our employees from leaving and taking our clients with them, or taking our secrets with them, or whatever it is that we've been protecting by sort of discouraging the employee. But when we think about loss of client revenue, customer revenue, if that's sort of what we're most concerned about, maybe we should shift the conversation and be asking, what is it that makes customers loyal to us as an organization, as opposed to this single person from our organization, right? How can we reimagine our relationships with our key contacts, clients, customers, with our brand, to keep them coming back to us, sort of irregardless of who they're working with in our organization. The next bullet point there really sort of ties into this, but it's this diversification of customer, client, key contact relationships, right? So, does it make sense? I think in the past, a lot of times customers and clients, and I'll speak to sort of professional service industry, they wanted their person. I want my CPA. And while I understand that there might be 5 other people working on my tax return or my audit, or pick your service, right? clients historically kind of wanted to work with that one person. But I would say candidly, I think even our clients understand now that turnover is more normal than it used to be. And even our clients are saying, change is hard. And if I just have more than one relationship, close relationship in the firm, for example, that makes them feel more secure. They feel that there's continuity in that relationship with that business or that partner that they're working with their clients, customers, whatever. So really building out this sort of 3x3 model in a lot of organizations might be a way to sort of hedge your bets, that even if someone leaves, that your organization still has solid enough relationships with your key clients and customers to maintain that relationship, that they won't follow that person when they leave, right? So the 3x3 model really means, does our organization have 3 people who are in contact with 3 people in our customer's organization because we're providing, 3 or more different kinds of services, or we're supporting in 3 or more different ways, or we're providing, 3 or more products, whatever, right? So it's expanding that relationship network within your most significant clients. And then last, but certainly not least, if we can't discourage employees from leaving via a non-compete agreement, we need to, and this is not just because of non-competes, but the focus needs to shift to how do we encourage them to stay because we're a great employer to work for, right? Retention by choice rather than by contract has to be our primary area of focus. And so I think really getting honest about why are people leaving? Is it culture? Is it compensation? Is it opportunity? Is it, where are they going? Are they going to competitors, or are they making bigger changes than that and they're sort of leaving the profession, for example? And so that's where we need to focus our time and energy. And then lastly, addressing those legacy non-compete agreements. Julia talked about all the legal implications of those legacy non-competes, what you can do, what you can't do, when they're enforceable, when they're not enforceable, what to watch out for. And that's all really, really important. But let's not forget about the optics internally for your employees who now know that they have non-competes and nobody else hired after them does, or none of the employees that came in with the merger have non-competes any longer. There's the whole, how does that sit with them while they're an employee? As well as Julie and I were talking about this earlier, but I have a suspicion that termed employees may be more likely to be mad about a non-compete if you try to enforce it when they know that other people are able to leave without a non-compete. So if you've got 2 employees, one has a non-compete, one does not have a non-compete because they were hired after July 1. And 2 years from now, you've had people come and go. They've seen employees leave and go to work for competitors because they didn't have non-competes and there wasn't anything you could do about it. And then that employee leaves and tries to go to work for a non-competitor. And you try to enforce that non-compete. I think there's probably, they will be more upset about these non-competes being enforced than they probably have in the past because it's going to be inconsistent. And that sort of dissatisfaction with enforcement of a legitimate non-compete could very well be a reason for litigation that wouldn't have happened otherwise, right? So I think we need to be prepared for that. And so really think about, does it make sense to keep your legacy non-compete agreements in place from an employee PR perspective, right? And especially if they're non-competes that, in light of everything Julia talked about with how the courts feel about them, if they're overly broad, if they weren't written all that well in the first place, it probably makes sense to have all your existing non-compete agreements reviewed. If they're probably not enforceable, it may be an act of goodwill that an employer could use to their benefit to say, hey, we're gonna waive these. I'm not saying employers should do that, but I think it's something to consider if you think it's going to be a problem in your organization. If they're good and solid and enforceable and they matter and you need them, then I'm not encouraging you to get rid of them. But it's something that we should all at least be having a conversation about and making a decision with intent, I guess. So, all right. So we are at, we have about 20 minutes left for questions, and I know there's been a handful coming in.
Maybe before you do that, before we get to the questions, Leah, so in the chat, I originally posted where I thought you could find the bill, and then I realized I posted an earlier version. So I deleted it. So if you were already looking at that one, don't look at that one. Sorry about that. I did just repost where you can find the statute. It's in a big omnibus bill where actually the sick and safe leave is as well. So if you're a total legislative geek and want to read through the whole darn thing, you'll be ahead for our sick and safe presentation in a couple of weeks here, or maybe it's a week or so, week and a half, I think. But the instructions are there. The link is there, and it tells you if you type in the top, there's a place where you can go to a specific line, type 66.10. That will take you right to the non-compete portion of the bill. So you can see it there. It goes from line 66.1 to line 68.6. So it's not real long. What I'd suggest is you just copy that piece and paste it into a Word document. It'll take off all the underlining and all the numbering for you. It should. And then you can just actually read the statute. But I will check with Larissa after we're done. I think we can also email it out to everybody. We have a draft of it already created and can get that emailed out to you. All right, so let's tackle a couple of the questions that I see, and I'll start, and Leah, maybe you can jump in as you see opportunity to talk about sort of real life implications. So the first question was, if you're a minority owner and employee of a business who signs a non-compete prior to actively selling a business, is the non-compete enforceable? Okay, so I think it needs a little bit of clarification on timing. So if it's before July 1, yes, because it's a legacy agreement. If it's after July 1, I think that goes to my whole conversation of we don't know for sure. I think the question is going to be, is selling a business, including selling a business interest, which a minority owner would have, versus everybody in the business selling all of their interests? Is that what a sale of a business means? And then what does during the sale of the business mean? I mean, from my perspective, when that person's buying in, that's a sale, right? It's a sale from one person to another. One person's the buyer, one person's the seller. That's the case in every sale. There's a buyer, right? It's not just a seller. And so I think, again, going back to if you craft the language around that the person buying in, that the person giving up their interest is selling their interest, their business interest or their business to this other person, I think there's an argument it is still enforceable. But that's one of those we don't know for sure answers. But a lot of it depends on timing. If you're talking about legacy agreements between owners, those would still be enforceable because they're not voided by the statute. The next question was, actually, I'd like to jump to the bottom one. If a company has a legacy, or what was the bottom? If a company has a legacy non-compete in place, can it be nullified? I think Leah touched on that, but I do have clients doing that right now who are saying, we are the only one in our industry doing these. We're having trouble attracting employees. We're worried about we're not going to be able to get them with new employees, and how is that going to affect our old employees? And so we want to nullify them. It's a relatively simple process. It's a document both parties should sign, nullifying the non-compete. Now, you may need to keep some portions of that agreement if there's confidentiality provisions, non-solicitation provisions. So you want to be careful that whatever you're doing actually reflects what you want to do. But if you want to get rid of your old non-competes, you can do that. Can we still do NDAs for recipes of products produced? Yes. Yeah, trade secrets are clearly protectable. And so your confidential information and non-disclosure agreement about your recipes, et cetera, clearly still protectable. They fall outside that covenant not to compete. And actually, as I said, have sort of been blessed that those are acceptable agreements to have. I'll let Leah answer this, government city one. In my experience, they're not, the question is, are non-competes common in government cities? I'm not familiar with there being a lot of them. I could see them maybe in an independent contractor relationship, that you don't want them going to other cities and telling your information. But Leah, you work a lot with government entities, school districts, et cetera, public employers. What's your thought about that?
Yeah. So quick answer is no, they're not common at all. So the answer of, is it common? Absolutely not. When you look at a public sector employer, they're subject to, information, data requests, and so everything is public for all, aside from confidential employee information and things like that. So there's really nothing to proprietary necessarily to protect in a government or a public employer situation. I actually did reach out to a couple attorneys that we partner with frequently that are specifically public employment, and they struggle to even think of a situation where a non-compete might apply. I suppose potentially in an independent contractor situation, but it feels like, from the conversations we were having, it felt like that would be more of a non-disclosure agreement. So for instance, maybe you had an IT company come in to help with your, database or security, and they would have access to resident name, address, or employee social security numbers, those types of things. You would probably most definitely have a non-disclosure agreement in some of those situations. But this non-compete agreement to sort of restrict post-employment or post-work, geography or access to clients or anything like that, there just isn't sort of a need for that necessarily in the public sector because of just the nature of operations and what you're there to do.
All right, the last question that we've got up here right now says, so I am hiring for a position I normally would have done a non-compete, the sales position. I'm thinking the best method would be to do a non-solicitation instead due to the new rules. If I go this route, do I have to ask them to do this at date of hire? Or can we get legal review and do later? Hire date is end of June, so I'm not sure if timing is going to work well. Yeah, so your non-solicitation agreements, your agreements after July 1st that are valid agreements, non-solicits, non-disclosure, confidentiality, are still going to be subject to the old rules about needing consideration, being reasonable in geography, duration, and what they protect. So that's still going to mean, at least at this point, we don't have any indication that the courts are going to change how they have looked at consideration historically, which has been, it either needs to be that it is in exchange for the job offer and signed at the start of employment. So generally that means they've got to have it. You can't say, we're going to give you one 3 months from now, but your job is dependent on you signing it. It needs to be ready and reviewable as part of the offer process is where it really should be, not even, given to them on the first date of employment. If you don't have it ready, can't have it ready, and you want to get one in place later, you're likely going to have some additional consideration required. That's going to mean some payment to them or something else they're not entitled to, not just continuing employment. It's been pretty clear that continuing employment is not consideration for a non-competition provision. We've taken some liberties on that sometimes with confidentiality because that one seems safer because there's some statutes around it, et cetera. But on non-solicits, I'd be safe and offer additional consideration if you're not going to be able to get that agreement in place as a part of the hiring process at the beginning and have the actual document. Now, what you give them for consideration, it can be, there's no bright line rule about it doesn't say adequate consideration, it just says consideration. So in theory, it could be $1 they're not entitled to. I think the question is always, how low do you have to hang the fruit to get them to sign it versus leave? It should be meaningful consideration. It should, so you're either going to pay them something that's meaningful, sometimes doing it around times where you would be adjusting compensation or commission structures or bonus structures is a time to get those agreements because they're not entitled to those increases. And so if you're going to do them, that can be consideration. You know, you were getting 10% of every sale, now you're getting 15%. But to get that extra 5%, you're going to sign this agreement. So if you can't get them in place by July 1, your new agreements, and you are going to want agreements later, you're likely going to have to do some consideration. And that could just be a timing issue, or it could be an outlay of actual money or other benefits to that employee. I think that's all the open questions. We've got about 10 minutes. We'll let you go early if there's no other questions, but if anybody else has got, some are populating in. Okay. If your legacy agreement includes a section titled non-competition that talks about damages for taking clients, does this become not enforceable? Should we change this wording? Okay, I would argue this statute only applies for contracts entered into after July 1st. So to the extent you have employees under that agreement already, they would remain under that agreement. Don't reaffirm them, don't change them, don't ask them to re-sign them, just sit on them. For your new employees hired after or who enter into agreements with you after July 1, that's where I think that there is a question about whether that is truly a non-solicitation agreement or is it against the spirit of the non-compete. As I said, there's arguments on both sides, and I'm seeing people who do the work I do, employment law lawyers, saying both things. There are some employment law lawyers who think, yeah, I don't think that's going to work. And there are others who say, yeah, I think it can work. I think you're not prohibiting them from working in a geographic area. You're not prohibiting them from working for another employer. You're not prohibiting them from working for another employer for a period of time. You're not doing any of those three things that are prohibited. You can go work wherever you want. You can go work for another accounting firm. You can go work for another medical device sales. You can go work for, you know, name your industry. But if you do that and you do work for our clients, you're going to pay us something. Again, how much do you want to push the envelope and do you want to be the guinea pig? A lot of it will depend on how much that's worth to you. Because if you get those damages and nobody challenges it and they're big enough, might pay for attorney's fees if you get a challenge later. You know, those are the things I think you have to weigh. If they're good and enforceable and you make back, you know, $250,000 in fees on one of these things and your attorney's fees don't get anywhere near that and you win, you're going to be money ahead. And you'll have set new law that was going to be helpful to us to answer questions and not say we don't know for sure. So hopefully that's kind of a long answer. Hopefully it answers. If keep those agreements that you have before July 1, don't mess with them, keep them in place unless you decide you want to get rid of them from a retention and recruitment standpoint. You know, that again, now you're going to have new employees not under this agreement and old employees who are, and how's that going to sit from a culture standpoint? Those are big considerations that aren't legal, right? But really important. Okay,
Great.
I think that is it. And we are at the end of our time or close to the end of our time. I hope that this has been helpful. Leah, do you want to wrap up and talk about our other webinars coming up?
Yeah, great. Thanks,
or
Julia.
Larissa, maybe?
Yes, just want to thank everyone for their time today. We had a big group, and the next 3 sessions coming up are universally applicable to all employers in the state of Minnesota. While there may have only been a smaller group that utilize these non-compete agreements, everything else we're going to be talking about is going to impact every single employer in the state of Minnesota. So our next session is on June 21st from 10 a.m. to 12 p.m. and we're going to be talking specifically about the safe and sick leave provision that goes into effect on January 1st of 2024. And we'll also be sort of giving you a preview of the Minnesota paid family and medical leave. That doesn't go into effect until January 1st, 2026. So we're going to give you a preview of that, but really focus on the safe and sick leave because that's the most pressing and time sensitive issue for Minnesota employers. And then the next session after June 21st will be related to marijuana in the workplace with the legalization of marijuana and what that means for employers. So we look forward to seeing you on June 21st. Feel free to register. All the recordings, slides, follow-up information will be sent to you after the session. And we thank you all for your time.
Maybe you said this, but there's a 4th session that's on the paid family medical leave as well. where we'll be deep diving into that. That doesn't go into effect until 2026. So you have some time, but it's probably one of the things I've been getting the most questions about from my clients. They're worried about it. We're going to have time to figure it out, but we're going to try to give you, an overview, a flyby of what's coming at that fourth session. So don't panic about the paid family leave. We're going to have time to figure it out. The sick and safe leave, you're going to have to figure out before year end and get your policies updated, and the drug and alcohol, especially if you do testing, you're going to have to get updated quickly. The paid family leave is going to be important, but we've got they did give us a little breathing room on that one. Not much breathing room on anything else though. So.
All right. Well, thank you all. Have a great afternoon and a great weekend.
And thank you, everybody. We'll see you hopefully at the next one.